This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why ambiguities in insurance contracts can be and were resolved by the finding of a jury, and that the jury's finding insurance contract language was affirmed by the Courts of Appeal. Madelaine Chocolate Novelties appealed the district court's judgment following a jury verdict in favor of Great Northern Insurance Company concerning storm surge damages caused by Superstorm Sandy to Madelaine Chocolate's production facilities. In a case entitled Madelaine Chocolate Novelties versus Great Northern Insurance Company, the United States Court of Appeal for the Second Circuit on June 20, 2025, affirmed the trial court ruling in favor of the insurer. Great Northern had refused to pay the full claim amount and paid Madelaine Chocolate only about $4 million. In disclaiming coverage, Great Northern invoked the policy's flood exclusion provision, which excludes in relevant part, quote, loss or damage caused by the rising, overflowing, or breaking of any boundary of any body of water, whether driven by wind or not, close quote. This flood exclusion, in particular, Great Northern relied on the portion of the flood exclusion commonly known in the insurance industry as an anti-concurrent causation clause, or ACC, which bars coverage for losses stemming from multiple contributing causes, provided that the insurer can demonstrate at least one of those causes is excluded under the policy. Great Northern's policy stated that the flood exclusion, regardless of any other cause or event that directly or indirectly contributed to the loss or damage, was excluded. According to Great Northern, Madelaine Chocolate's damage was caused, at least in part, by wind-driven flooding, and was thus excluded under the ACC clause of the flood exclusion. Following Great Northern's denial of coverage, Madelaine Chocolates sued for breach of contract, and after a week-long trial, the jury returned a verdict in favor of Great Northern. New York law imposes a heavy burden on the insurer, who must prove that, quote, its interpretation of the exclusion is correct, close quote, to avoid application of the, quote, rule of contra preferentum, which generally provides that any ambiguity in the policy should be resolved in favor of the insured, close quote. This case highlights the complexities involved in interpreting insurance policies, especially when multiple clauses and endorsements are present. The ambiguity created by the windstorm endorsement's ACC clause vis-a-vis the flood exclusion demonstrated that challenges insurers and insureds face in determining coverage. The case also underscores the heavy burden placed on insurers to prove their interpretation of policy exclusions. Great Northern had to demonstrate that its construction of the policy was the only reasonable interpretation to avoid coverage for storm surge losses. The court's consideration, therefore, of extrinsic evidence, including the parties' subjective intent and objective conduct, emphasize the importance of such evidence in resolving ambiguities in insurance contracts. The case illustrated the significant role juries play in interpreting ambiguous contracts and assessing the intent of the parties. The jury's verdict in favor of Great Northern, despite the ambiguity, showed the weight given to the evidence presented during the trial. For policyholders, this case serves as a reminder to thoroughly understand their insurance policies and the implications of any exclusions or endorsements. It highlights the importance of clear communications with insurers about coverage expectations and clear communications from the insurer about the coverages provided. In my opinion, it is often claimed by pundits in the insurance world that interpretation of insurance contracts is too complex for juries to resolve and should be limited to the wisdom of a district court judge. This case makes clear that juries are equally, if not more, capable of interpreting an insurance contract's terms and apply evidence presented at trial to understand the alleged ambiguity in an insurance contracts. Judges are no more human than a jury of the peers of the parties to the insurance contract and should be allowed, as did the court in this case, to resolve coverage issues. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,100 blog postings. You can also subscribe to these videos. They're free. And please tell your friends and colleagues about the blog and these videos so that they too can subscribe. They're free. And if you're interested in further detail about insurance claims, consider subscribing for a very small fee to my Substack publications. Thank you for your attention.